Hi everybody. Hi everybody, my name is Jen and you're very welcome back to Law Hero. This morning I would like to go through a new judgment called Smith v Cunningham, and this is important for anybody who is sitting tort, be it in King's Inn, FE1, or indeed is just interested in the area of professional negligence, which is like most of us who are involved in litigation, or even if you are a practitioner yourself, this case is really important. So I'm going to go down through it for you guys, okay? So this Court of Appeal judgment was released on the 20th of October 2021, and it gives clarity around the application of the statute of limitations in proceedings involving solicitors and other professions that will have far-reaching effects on the professional indemnity market. So obviously how practitioners protect themselves is through professional indemnity, which is basically insurance that they pay out of if they are found to have been negligent. It's a way for them to be covered. Indeed, you cannot practice as a solicitor if you do not have professional indemnity insurance. Usually if you work for a law firm, it's covered by like a group premium. If you're out on your own, you have to pay it yourself. If you're in-house counsel, you don't have to pay it. And also barristers have professional indemnity insurance. Okay, so the background to the case is the Lads, I can't even speak today. The background to the case is the Supreme Court's decision in Brandley v Dean 2017, where clarity on the limitation period applicable to claims taken in negligence where damage to property occurs. This is the whole, like, when does the clock start to begin for the purposes of Section 11.2 of the Statute of Limitations Act 1957. The Acts state that an action founded on tort shall not be brought after the expiration of 6 years from the date on which the cause of action accrued. In Brandley, the question was whether the plaintiff's cause of action had accrued upon the laying of defective foundations in 2004, in which case the proceedings against the defendants would have been statute barred because 2004 plus 6 would be 2010. Or in 2005 when the cracks in the house first started to appear. And when I was a trainee, I was involved in subsidence cases, and that is another issue altogether. When the house starts to slide, when did they notice the house started to slide? Indeed, in subsidence cases, that's when you notice cracks, it means the house is starting to slide. The Supreme Court ultimately found the cause of action accrued in 2005 when the damage manifested itself and was capable of being discovered. So this is the whole latent and patent damage. So latent is like it's within the infrastructure, patent is you can see it. So it would have to be patent damage in order for it to be discoverable. And it brought certainty to, you know, construction cases. However, when it comes to professional negligence and financial loss, it is less clear. There is no, when the damage was observed. Here it's kind of different when it comes to somebody's like livelihood or their investment. And indeed in the FE1 question, we were asked about somebody's investment that had knock-on effect that was because of professional negligence was lost. So let's look at the facts of this case. So in April 2006, the plaintiff entered an agreement with the defendants for the purchase of a newly constructed house in Leitrim. The property had been granted planning permission subject to several conditions. In March 2006, after construction was completed, an engineer, who was the first defendant, certified compliance with both planning permission and building regulations. This basically means they hand over these certs. When the buyer saw these certificates, they were like, okay, house is grand, and they bought the house for $240,000 in July 2006. The defendant's solicitor acted for them the fourth defendant, which became the plaintiff's solicitor, acted for them. So the plaintiff's marriage broke up and they went to put the house in the market. So this was 2 years later in May 2008. And They agreed to sell the property for 280,000. So that's interesting, went up by 40,000 in those 2 years. An issue arose when the purchaser's solicitor did not receive the original planning. So they rang up Leitrim County Council looking for confirmation that all the planning regs had been complied with. The council responded and said the property was not compliant with the conditions imposed by the planning and that it had been referred to the Building Control and Enforcement Office. Uh-oh, that's not good. When this was relayed to the purchaser, they decided against proceeding with the purchase. Of course they did, because there's something dodgy with the gaff. The property's planning issues were remedied soon after. They got a grant of retention in November 2008. But for the plaintiff, in the interim months, the property market collapsed due to the financial crisis, and he was unable to sell the property. The property was eventually repossessed by the mortgage lender in 2010 because the plaintiff could not keep up with his payments. So now he is peeved. Proceedings claiming breach of contract, breach of duty and negligence. So breach of contract isn't contract, breach of duty and negligence come under tort law. He issued these in 2014, which is like 4 years after he went into repossession, which was probably a bit long to wait. But it was also 8 years after he bought it in 2006. And nearly 6 years when the planning issues came to light. And 5.5 years after the failed sale of the property. So the solicitor brought a motion to use the statute of limitation to strike it out. They admitted the claim was statute barred, so both sides admitted the claim was statute barred because of the 6-year rule. So the High Court had to decide whether the plaintiff's action in negligence had accrued upon either the purchase of the property with the defective planning in 2006, or was it when the sale occurred in 2008 when the plaintiff could have been said to have suffered financial damage. If the former was found, the plaintiff's claim would be statute barred. So, i.e., was it when he bought it, or was it when he sold it? If it was when he bought it, he would be statute barred. In considering the submission, the court applied Brandley and found that the determinative distinction at hand was one between defects and damage. In Brandley, the court said the time limit did not begin to run from the date of the underlying effect. It was obviously when it was discovered. Applying this to the facts at hand, the court found that defective planning permission at the time the plaintiff purchased the property was merely a defect, and the damage did not manifest itself until he went to sell it, which is what I would have said instinctively. You wouldn't have known it until you went to sell it, but of course they say the day you buy is the day you sell. As such, he was within the 6 years. So obviously the defendants appealed it to the Court of Appeal. Now let's see what happens in the Court of Appeal. So the defendant appealed the decision, claimed the High Court had misapplied the Brandley principles. This was largely based on the submission that those principles are restricted to property damage claims, which is a fair point. The defendant submitted that there were defects to the property's title that were capable of discovery on purchase, and that the property was immediately devalued as a result. So they were saying it happened at the time of purchase. The resulting loss of value caused by the defects must have been said to cause the damage, thus beginning the time limit under the statute of limitations. The plaintiff counted that there had been no loss suffered upon purchase because it wasn't discoverable, and that any loss or damage as a result of the defective planning permission was purely hypothetical because they hadn't gone to sell it yet. Accordingly, the time limit could, according to Brandley, the time limit could only run on this date. They also pointed to the case of Gallagher v ACC Bank in 2012, which I have mentioned in my notes. So let's see what the Court of Appeal decided. So they quoted heavily from the Brandley judgment, where it was stated that while some torts may be actionable per se, the tort of negligence was not, and required damage to occur, at which point the cause of action accrues. Time begins to run from the date of manifestation of damage, which means it runs from the time that the damage was capable of being discovered and capable of being proved by the plaintiff. The Court of Appeal went on to say that the occurrence of damages and its manifestation will often be simultaneous, and that in cases of property damage, as in Brandley, Differentiating between defects and the manifestation of damage was more readily done. This was not so the case in financial loss as it was here, where it is difficult to point to an exact moment where the cause of action accrues. So then they looked at the Gallagher case, which discussed the Cantrell v AIB case. In Cantrell, where Gallagher was analysed, the court said that damage must be defined pragmatically as real actual damage which a person would consider commencing proceedings for. The court said, as the Supreme Court did in Gallagher, that the mere possibility of loss does not in itself constitute damage, so that's actionable per se, sufficient to accrue a cause of action in negligence. Crucially, however, Gallagher was qualified in that any loss of value to an asset could not be seen as mere possible damage. This was accepted by the Court of Appeal that said that actual damage can be suffered on the occurrence of a transaction and that a cause of action may accrue before a plaintiff is capable of quantifying a claim. The occurrence of a transaction can cause loss rather than the discoverability when you go, for example, to sell, which is another transaction. Actual damage capable of discovery occurred to the plaintiff when he purchased the property, in that he did not receive good marketable title, which is what you have to receive when you purchase a property in Ireland, and in effect purchased an unauthorised development. The High Court had stated that it was still open to the purchasers at the time to complete the purchase, notwithstanding the planning issues. It was only on rescission of the contract that damage could be said to have occurred. But the Court of Appeal disagreed. It said it was because of the damage that the purchase could not be completed. As such, the limitation period began on that date, and therefore the plaintiff's claim in 2014 was statute barred. Even in cases of contingent loss, which was not the case here, the loss was actual loss suffered at the time he bought the property. The manifestation of damage is likely to occur simultaneously with an alleged defect, and thus the statutory limitation period will begin sooner than cases involving the latter. This will, of course, depend on the facts of each case. I hope you enjoyed this video, and please let me know what you think, and I'll see you in the next one.